let me ask this first question. We've heard here today that there were intentions for PTAB, what it was set up for 10 years ago, but I'd like to know I'll ask you, Mr. Kapos, first, who are the most frequent filers at PTAB?
So I think that some other witnesses have put records, statistics in the records. My understanding is that there are a number of very large tech companies that are the biggest filers by far.
Mr. Mittal, who are the biggest filers, the most frequent filers, sorry?
Basically, the people who get sued the most often. It does tend to be the larger companies. In fact, larger companies use the proceedings more than the proportion that they are of the litigation. Part of that is the fault of lawyers like me. When you have a client that's a smaller business or only has secondary liability for using something or selling it, you often go to them and say, this is who really made the product.
Ostensibly, what are these companies that are getting sued for?
For patent infringement.
Okay, thank you. Mr. Bright, who are the biggest filers at PTAB?
So the top
most frequent, sorry.
Yeah, the top petitioners include Apple, 673 petitions, Samsung, 549 petitions, Google, 354 petitions, and Microsoft, 227 petitions. 82% of 14,000 PTAB cases are large corporations. 40% of the 14,000 PTAB cases are large corporations against small competitors. Only 2% of the 14,000 PTAB cases are small businesses versus NPEs. So that's kind of the top stats.
Can companies from China file in PTAB and invalidate American patents?
Yes.
And how frequently does that happen?
I would have to double check the stats on that and get back to you with that.
Okay, thank you very much. So forgive me if I'm a little leery of this theory that the PTAB was set up and established and has succeeded in helping small companies and small inventors. Mr. Rogers, can you tell us how much does it cost if you're an inventor? You had to go against Cisco and are still trying. How much does a PTAB case cost for your company?
It costs an enormous amount, and part of that is driven by the standards. There's no presumption of validity on the patent. If a trial gets instituted, the statistics are that you have an overwhelming odds of having the patent revoked. So there's a huge amount of expense that is incurred right up front to try to not be instituted. And this isn't a case of a single bad patent. As you saw in the case with Cisco, it's a salvo of 14. Multiple overlaps, different theories on the exact same patent. So it can be quite extensive.
You said something that kind of caught my ear. You said that people without standing can bring cases in front of the PTAB. Is that correct?
Yeah, and anybody can bring a patent case to the PTAB.
I mean, I'm not a lawyer, but that seems to run afoul of sort of some of the principles of the real court system that exists. Mr. Kapos, was that the intent of PTAB, to allow people who have no standing to basically bring forth a patent and try to invalidate it?
Yes, that was the original intent. The thinking was that the estoppel that came with, the consequence of estoppel that came with bringing an IPR or a PGR would create accountability for parties. But this is why I mentioned before that degrading estoppel moves actually away from the original intent of the IPR system, and it creates more problems for the issue that Mr. Bright is raising.
Mr. Bright, is the appropriate analogy here to patents was the closest thing, like one that I use, but is it appropriate to say that they're like deeds to property?
Yeah, one of the really fundamental important aspects of a patent is that it's an opportunity to facilitate transactions. So when you have certainty of patent rights, it allows parties to know what's being transferred from one party to the next. It allows investors to know with certainty what exactly they're investing in. And so it's really fundamentally important that it be a solid, determined right. And then just real quickly for the record on your question about the Chinese companies. So Huawei filed 114 petitions, HTC 115, ZTE 127.
Yeah. Thank you very much. I would like to submit to the record, if it's possible, the dissenting decision Justice Gorsuch on a recent case. He says, after much hard work and no little investment, you devise something you think truly novel, then you endured further costs of effort of applying for a patent, devoting maybe $30,000 to the process, affords you exclusive rights to the fruits of your labor for 2 decades, but what happens if someone later emerges from the woodwork arguing that it was all a mistake and your patent should be canceled? Can a political appointee and his administrative agents, instead of an independent judge, resolve the dispute? That's the basis of PTAB, is to say that we're not gonna give you a real court, that you're gonna get a political appointee who's gonna decide whether you get to keep that right or not that was guaranteed, frankly, and very clearly in the Constitution. I yield back. Mr. Kapos, how many IPRs are permitted against a single patent to be filed?
No limit, could be infinite.
There's no limit? Like, what's the most you've heard of?
I don't have specific data, but I know of cases in which, multiple IPRs have been filed against the same patent.
Has there been as many as 26?
It could be. Sounds like you've got data better than mine on that. That's a large number. Mr. Massey, I would just say we did not intend.
Let me get to the point of it. Yeah, and I think you understand the point of the question is, was that an intent to allow serial filings at PTAB from people who are trying to invalidate patents?
No, not to that level or anywhere near it.
Okay, so unintended consequence. Mr. Rogers, does the PTAB shorten the duration of litigation, or does it lengthen it?
Absolutely not. It lengthens it and quite considerably.
So in your case, how can you assign a number of months to how much longer you think it's put you in the market watching your competitor use your patented technology against you? How much longer have you had to endure that because of going through PTAB?
Well, the tactics now are to foul the docket at the district court, telling the district court that you're going to assemble IPRs and putting the process in jeopardy in order to try to get a stay. And then upon institution, maybe of some or not, then there will be the actual stay. There's the year that the PTAB process has to go to conclude, and then after that you have to go back to the court and try to get rescheduled to pick back up again. So it's very easy to have 1 to 3 years of added delay.
And what was the amount in your case?
In our case, it was at least a year.
At least a year. Mr. Bright, if the PTAB is faster, cheaper, and accurate at resolving disputes, why are inventors opposed to it?
Oh, because I think they would disagree with that characterization.
Which one? Is it?
Yeah, all three
Okay.
of those, yes.
So if it's, it's been said here today that it's more accurate. Can you say why you disagree with that?
I think that it's looking at it through a filtered lens. So if you lower the standard in terms of what is the standard of review, and you allow there to be multiple sets of arguments made over and over again, then just the mere probabilities, you're increasing the opportunity of hindsight bias. So the vast majority of patents that get thrown out don't get thrown out on anticipation, which is, a single reference that already described that invention. Most of the time, it's built on a combination of references of what's known as obviousness. And that hindsight bias is something the Supreme Court has warned against for years, because the more you look at something that feels like it's normal every day that you get used to, the more likely that you're going to assume that it was obvious invention.
Mr. Rogers, can it be more accurate if it doesn't allow discovery? And how, you've been through PTAB and a court case, is that correct?
We have.
And how did discovery, the ability to have discovery, change the decision or influence the decision of the judge or the jury?
Well, a telling example is Cisco made certain arguments that our patents were obvious. We went through the PTAB. And when we ultimately got discovery, we got access to emails that said we need to go and study Centripetal's patent claims. That was a pretty telling and jarring example. And source code tells a very different story about when technology was implemented and why than just looking at some reference.
And do judges take that into consideration when they make a determination of obviousness, for instance?
At the PTAB, they do not.
But in the courtroom, they do?
In the district court, you have the full benefit of that.
They try to get an appeal, and the court says, well, we're going to agree with the PTAB, but we're not going to review it. Mr. Bright?
I think what you're referring to is just a summary affirmance at the Federal Circuit. So they don't issue a written record or an opinion about why they agree or disagree with the lower court, the PTAB's ruling. They just give it a Rule 36 affirmance and say, affirmed.
Maybe one of the fixes we need is to say you can't do that you've actually got to get a day in court, and the court can't rubber stamp the decision.
I really do appreciate this hearing, because we're getting to the crux of concerns that some of us had 10 years ago. And since then, having heard from so many individual inventors about the very thing, Mr. Rogers, you just outlined, this hasn't made things faster. It hasn't made things more quick. And in fact, instead of having a more independent decision made, we seem to have more political effects being made. And for heaven's sake, to be able to have foreigners come in to PTAB and question the validity of patents, when at least on the surface, they don't have any standing. They wouldn't be allowed to come in our federal court because, as far as we know, they don't have standing. Now, if they want to come in and say, we're getting paid a bunch of money by our country to come in and create chaos in the U.S. patent system, that would be nice. But that's why I say on the surface, we don't know that they had any standing. So these are things that need to be addressed. And I appreciate the comments, Mr. Cabos, that we need to move, and others have made it. Let's get away from preponderance. When you're talking about ripping out a patent that took so much to get established, let's move to clear and convincing evidence. That really should be one of the first things we do. But we're not always accused of being prudent in our decisions, which is why, parenthetically, there's a rush to have a gun bill, even though the U.S. Supreme Court has just ruled a New York law unconstitutional. Prudence would say, let's hold up and make sure that what we're about to do is constitutional under the law right now. But like I say, prudence is not normally a real attribute here in Congress. But I would yield to my friend, Mr. Massey, for the rest of the time.
I have just a quick question for Mr. Bright. Would private capital, angel investors, venture capitalists, would they be more likely to invest in new technologies and ideas if PTAB did not exist?
Yes.
Interesting.
That kind of runs counter to some of the narratives here that have been circulating for 10 years. Mr. Rogers, would you have been better off if PTAB didn't exist? Would you be more likely to prevail in court?
Absolutely. The case that today of the disqualifying financial interests that eventually, coincidentally, snuck into the situation. We were delayed for years. That happened days before the decision was entered. So the PTAB is a very effective...
Gentleman's time has expired. You may continue with your response, though, sir. I didn't mean to interrupt you.
Thank you, Chairman. The PTAB is a very effective dilatory tool.
I want to follow up on the live testimony request. Ms. Ellison, do you think that's something the judges would like, or the petitioners or the defenders?
I think some of the parties would like to see that happen more often.
That's what I've heard. I have one inventor who said that the judges, like there was a dog barking in the background when her case was being heard in front of these PTAB judges, and she thought it was extremely disrespectful and didn't convey the weight and the gravity of what was happening, that she was possibly losing her livelihood. Mr. Bright, you've talked about how when there's no good presumption of validity to a patent, there's less deal flow, there's less investment into those technologies. But I'd like to ask you, and I'll ask you also, Mr. Rogers, You know, the U.S. military relies on secure communications, technology, equipment, satellites, networks. And do you think that it's possible that PTAB has contributed to the lack of development of that here domestically, or that possibly China's taking advantage of the fact that we have a weakening patent system due to PTAB, and that we don't have enough investment in things that could provide more national security?
Yeah, I'll defer to the experts about the actual security technology and what is involved in that. But what I'll say is the overall trends that when we look at the venture capital data and where they're making investments, over the last several years, they have not been investing as much in those technologies as they have been in other shorter-term technologies and things that are not in that cybersecurity area or in that security, national defense security area.
Let me ask you that question, Mr. Rogers. You've worked in this field for the government, is that correct?
I have.
And so do you think there could be a problem here in the fact that we don't have the presumption of validity that we should have in our patent system?
Absolutely. I know from my experience that that's the case because when you are going to disrupt a big legacy technology industry like ours, for example, there's embedded software, there's next generation hardware, there's application software, there's all of the support infrastructure around that. We build and manufacture all of that in the United States. It's a massive investment. And unless you have that quiet title to be able to protect that investment isn't going to be made. And we've seen over the past decade, venture capitalists fly exceptionally fast to what is the app that we can back and flip and sell as quickly as possible. And that isn't the strategic technology that is needed for national security.
So, and China clearly has a national security policy of trying to develop those things domestically in their country. Do you think they are advanced enough or smart enough to take advantage of our patent system using PTAB to tilt the table?
Absolutely. It's another tool in a very long strategic effort. And it's no coincidence. The former head of software for the Air Force resigned, and on his way out, he said, "We have lost the war on artificial intelligence technology, but we just don't know it yet." That's happening rapidly right now.
That's troubling. I'd like to ask unanimous consent to submit for the record an article called China Hijacks U.S. Patent System to Steal American Inventions. I don't think they even really have to steal these American inventions. They just have to take away the desire or the ability for people to invest in these inventions that are critical to national security. Did you have something to add, Mr.
Yes, if I could, Congressman Massey. Another issue, besides the one you raised, is the lack of a presumption of an injunction against an infringer. So the fact that that was taken away 15, 16 years ago now allows a Chinese company to assume that even if they did appropriate somebody else's technology, they're going to still be allowed to use it.
Isn't an injunction the biggest thing that deters somebody from infringing? I mean, if you merely get caught and have to pay the royalties that you owed before, that's not much of a disincentive to steal technology. But isn't it true that most inventors and investors really do rely on injunctions?
Yes, that is correct.
That's because if you're a big company, that's the biggest threat you have, is that you have to quit shipping something that you've already marketed. And just continuing my unanimous consent request, I asked unanimous consent to submit this article. It was in usinventor.org, for the record.
And the only additional perspective that I'd offer is that we've gone very hard over in this balance of equities to the users of this system who are largely trillion-dollar firms. And the legal budgets here are likely a small fraction of a quarterly dividend. And to get balance back in the system, we need to think about patent owners.